now let's welcome our guests for this hour, criminal defense attorney Sam Bassett and former law enforcement officer Claudia King. Sam, talk about this for us. Talk about the fact that we know the defense is going to come out swinging and say, no, this was consensual. He didn't do any of this. She hired the escorts. Who are you going to believe, her word or his? A billion-dollar entertainment god to the minds of many just in terms of his music. How do you prepare a witness who's a victim like her for that cross-examination that eventually is going to be coming?
I think you just have to take her through some mock cross-examinations. You have to give her some general ideas about what to expect. Obviously, the defense is going to harp on her free will and her actions that she did independently. And then the prosecution obviously is setting the stage, laying a framework for how much he controlled her and how much she relied upon him for so many things. But the defense, obviously, the way you prepare the prosecution witness is to perhaps even bring in some defense attorneys to do mock cross-examination so she can understand the types of things that she will go through on the witness stand.
Yeah, all great points, and I'm sure she's been prepared for the cross-examination. Sam, let's talk about this. The prosecution gave, as part of their opening statement, they said this, and I want you to consider this. The defendant told Cassie that if she defied him again, he would publicly release the videos of her having sex with male escorts that he kept as blackmail. Souvenirs of the most humiliating nights of her life. Blackmail. Now, does that piece of it speak to you as to the racketeering charge that he's facing, that he did this to lots of individuals, lots of women?
Yes, the threats to publicly humiliate and to control the narrative are very important to the overall racketeering charge. Bringing in people from out of state, having them do acts against their will, and then if they rebel or if they resist in any way, let them know, by the way, you will be embarrassed. I will release these videos. Your family, your friends might see them. It'll be on social media. It'll be on different types of sites on the internet. So yes, it's definitely a next level of threat because so many people are involved and it would be distributed to so many thousands of people in the public.
Great point. And to me, this is almost, in terms of what the prosecution has laid out thus far, an example, a perfect example of what a predator looks like. And that's what the prosecution wants to present to this jury so far. I think that they are doing that. Stand by, guests, please. Coming up, we're going to switch gears and head to Massachusetts for the Karen Reed murder retrial as we look ahead to key witnesses in the case. All that and more right after this very quick break. All right, a lot going on. They are at lunch, so that resentencing hearing is still happening. They're on a lunch break, which is why Mark Garagos was able to come out and speak to the press. Still with us, criminal defense attorney Sam Bassett and former law enforcement officer Claudia King. Let me ask you, Sam, as you're listening to him, and I really like that he focused on the resentencing hearing purpose, to look at the redemption and to focus on the rehabilitation. Number one, do you agree with that interpretation? And number two, it makes it sound so easy. By all accounts, these two have been model prisoners, but I don't think it's so easy or straightforward for a judge.
I think he's smart to focus on the statute and the language in the statute that emphasizes rehabilitation and the risk assessment. I do think that there is some evidence of some misbehavior on the boys' parts, the young men's part, while they've been in prison, sneaking in a cell phone, maybe some other minor misbehavior. But he's smart to narrow that focus. Obviously, the DA is going to revisit the horrific facts of the case, regardless of what Mark Garagos wants him to do, to remind the court of what they did.
And as I understand it, I think that they would have to go before a parole board for a hearing. I know Garagos is saying they're going to ask that not have to happen, they be released. I'm just looking at the law. I'm not quite certain exactly where the court may be able to come down on that. We'll have to wait and see. All right, stand by. We have so much going on today. When we come back, we're going to return to the case against Karen Reed. So much to discuss, and looking back at Michael Proctor and that investigation. Stay tuned. We'll be right back. Still with us, criminal defense attorney Sam Bassett and former law enforcement officer Claudia King. All right, let me ask you, Sam, about the gag order, because these attorneys have done a yeoman's job, and I've seen them do nothing to violate, not that they would, but it can be hard sometimes to remember, wait, I can't say anything about the case. So they've said nothing about this case. We have heard from Karen Reed. She's been very, I think, appropriate, somewhat refined. She's not just talking and talking and talking. She's very responsive. She seems to be handling the stress of the trial. What is it like to have a gag order as the lawyer and not be able to talk about the case when you leave that courtroom?
For me, it's a load off my shoulders in a high publicity case.
Interesting.
It lets me focus on my job and not on the circus outside. I know that the media is an integral part of our country and the coverage of trials is essential, but I really, once a trial starts, and certainly around the time of trial, I really like to be focused on the situation at hand. However, as you see with Mark Garagos, sometimes the publicity and the surrounding awareness by the public can influence what happens inside the courtroom. I think it's naive to think that jurors follow every instruction to not pay attention to the media, but even though they're told to do so. So it's to me, a gag order is almost a relief in some ways.
And that's why we have experts like yourself on, Sam, because I hadn't really thought of it from the perspective that it may ease a burden because you're not allowed to. So that's really great insight. Let's listen together now, because I want to talk a little bit more about Karen Reed and her being outspoken, and listen together to an interview that she gave about whether or not she thought maybe she hit him.
I remember it, but I question, do I remember it because it's been relived so much? I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember it on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that, so the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Yeah, Sam, just quickly, former law enforcement saying, defendants, you shouldn't be talking. Is this going to be a nail in a coffin for Karen Reed, so to speak, that she said so much to the public, just really quickly?
It certainly eliminates the possibility in my mind that she'll take the stand, because she can immediately cross-examined on everything she said outside the courtroom.
All right, thank you. I know we're out of time. Michael Ayala joining me next for more key testimony in the Karen Reed retrial. Stay tuned.